Hello and welcome back to my YouTube channel, Going Places with Abu Micah. In this video, I'm going to be talking about the mobility rights of provincial nominees in Canada. Can you move to another province after migrating as a provincial nominee? After how long can you move? What legal issues are involved? Will the other province quiz you as to why you're moving there? Will it affect your application for citizenship? These are questions that people ask in reference to provincial nominee programs and permanent residence. I'm going to try to answer these questions by looking at two pieces of legislation which are very important to know and understand. If you want to find out more about that, do stay tuned. Okay, so I have already done a video about Canada's provincial nominee programs, so I'm not going to go into the details of explaining what the provincial nominee programs are and how they work. You can follow this link and watch the video. It's 7 minutes long. But this video is just about the mobility rights. Now, in order to begin to address this question, we have to look at two very important points. Number one is that immigration in Canada is administered at federal level, not at provincial level. No province can give you immigrant status in the country. Okay? There are certain aspects that are provincially managed, other aspects that are federally managed, and immigration is a federal issue. The second thing is that Canada does not classify its permanent residents to say these are the investor class of PRs. This is the family class of PRs, those who are sponsored by families. This is the resettled refugee class of permanent residents. This is the provincial nominee class. This is the Quebec class. Canada doesn't do that. When you're a permanent resident of Canada, you are as much a permanent resident as everybody else who is a permanent resident, regardless of how you actually became one. Okay. Now, back to the first point about immigration being federally managed. Provinces, where they come in is that provinces can nominate you for PR based on how well you meet the needs of the province, how well you can contribute to the economy of the province. Okay. So you have to apply to the province for nomination, and then the province processes your application and gives you a nomination. Once you get the nomination, you can and should apply to the federal government for immigration. Okay? Then you become a permanent resident like everybody else who is a permanent resident. Now, let's go on to the two pieces of legislation that I was talking about at the beginning of the video. The first one is Section 6 of the Canadian Charter of Rights and Freedoms. This, I'm going to put the legal wording here so that I don't misquote it. You can read it for yourself. Section 6 gives every Canadian citizen and every permanent resident of Canada mobility rights. The right to live and work anywhere in Canada. As long as it's in Canada, you can live and work there if you're a Canadian citizen or a permanent resident. Okay? Regardless of the fact that you may have immigrated as a provincial nominee. Okay? Now, I'm going to look at another section, which is Section 127 of the Immigration and Refugee Protection Act. Now, before I go there, when you are making an application for provincial nomination, one of the key eligibility factors is your intent to settle in the province. Okay? You must make a good faith application for nomination. Let's say you're applying to British Columbia. Okay? I'm just using BC as an example because it's the most beautiful place on earth. I was there this afternoon. I'll talk about that in another video, hopefully. But you must intend to settle in that province. Okay? And that's very important for a reason I'll talk about just now. Now, Section 127 of the Immigration and Refugee Protection Act makes it an offense. I'll put the legal wording here, but it makes it an offense to make a misrepresentation of a fact that can affect the processing, the administration of the act. Okay. So, if you make a misrepresentation on your immigration application that affects the administration of the act, that's an offense. you can have your status revoked if it is discovered that you made a misrepresentation that affected the administration of the Act. Now, how does that apply to PNP nominees? When you're applying, remember I said you must have an intent to settle in BC. And then BC processes your application and nominates you on the basis that you intended to settle in BC. Of course, in addition to all the other eligibility factors. Then you apply to the federal government for permanent residence on the basis that you have been nominated by BC or Ontario or Saskatchewan or whatever province, right? And then you get the PR. Now, if it is then discovered that you misrepresented your intention to settle after you've been granted permanent residence, then you can have your status revoked on the grounds of misrepresentation. Okay? It's different from when they ask an express entry applicant like myself. I was not a provincial nominee, but they did ask me on the application where I intend to settle, right? And it's not something that would contravene Section 127 if I say I want to live in Alberta, but then I land in Nova Scotia. Okay? They don't ask that for the processing or for the administration of the Act, but they ask that for statistical purposes. So even though I wrote on my application that I intend to, I want to move to Edmonton, Alberta. That's what they wrote on my COPR. But then I could have landed in Vancouver and stayed there. I wish I had. But it's just for statistical purposes. But it's different from PNPs because PNPs is actually something, it's not for statistical purposes. They really want you to move to that province. Okay? So how do you avoid that? What legal issues affect that? Okay? Now, for the most part, the federal government, even the province that nominated you, isn't going to come after you to follow up and see whether you are living in the province, whether you're working in the province. They're not going to do that. If you land in Ontario as an OINP applicant, and you decide to move to BC, BC isn't going to question you as to why you're moving from Ontario. They're not. You just move as any other person would move. You're a permanent resident. Section 6 applies. But if at any point you are questioned about your move to BC by either the provincial government or the federal government, you should be able to justify your move. Okay? Now that's subjective. So there's no set time or fixed time to say, okay, you should have spent 1 year in BC. Or what if it didn't work out in BC? Right? So you are allowed to move, but as long as it's necessary for you to move, as long as you can justify the move, as long as you can show that your move was not something that you had planned before you landed in Canada. Okay? I'll just try to give a little analogy here, which I hope may clarify things a little bit more. I'll use the analogy of marriage. Okay? Nobody gets married, enters into a marriage saying, I want to marry this one and then divorce and then marry someone else. You say nobody does that. But people get married and people get divorced every time. Okay? All the time. But the important thing is when you do get married, okay, you must have a genuine desire and intention to make the marriage work. But of course, things may not work out. So it's the same with provincial nomination, okay? You should have a good faith application when you make a provincial nomination application. But things may not work out. And in such a case, you can move to another province as long as you have ample evidence to show, if you are ever asked, why you moved. So I hope that sort of answers the question. If it does, good. If it doesn't, well, feel free to drop some comments. I'll try as best as I can to clarify anything else that you want me to clarify. But otherwise, I hope you found this video useful. If you liked it, thumbs up. I'd love to hear your feedback. And if not, I'll see you guys in the next video.